Potentially, yes, but it depends on why you served 4 months instead of one. If, for example, there was a sentencing or calculation error, you should have been released earlier, but weren't, jail credits, dead time, were miscalculated, or your charter rights were violated, then there may have been grounds to challenge it or even sue for wrongful imprisonment or false imprisonment, depending on the circumstances. Every case is very fact specific. The bigger issue is timing. If this happened in 2018, 2019, it's now several years later. In Manitoba, most civil claims have limitation periods, often around 2 years from when the claim was discovered, although there are exceptions in some situations. That doesn't automatically mean it's impossible, but it does mean a lawyer would need to determine exactly why you remained in custody, whether any limitation period expired, and whether any exception might apply. I'm curious about one detail. When you say you were supposed to do 1 month but ended up doing 4 months dead time, what actually caused the extra 3 months? Were you waiting for court? Did your sentence change? Was there a paperwork or administrative mistake? Or was bail denied and you spent extra time on remand? That detail makes a big difference in whether there may have been a legal claim. If the extra time happened because the Christmas holiday started, that by itself usually wouldn't justify keeping someone in custody for an additional 3 months. A long holiday weekend can sometimes delay things by a few days. A bail hearing, sentencing, processing release paperwork, or arranging transportation. But a Christmas closure wouldn't normally explain an extra 3 months in jail. So I'd want to understand the timeline a bit better. For example, were you already sentenced to 1 month and your release just kept getting delayed? Or were you on remand waiting for another court appearance after Christmas? Did something happen in January or February that prevented your release? If there really was an administrative error that caused you to remain incarcerated significantly longer than your lawful release date, that could have been a serious issue. However, after 7 to 8 years, pursuing a lawsuit would likely face significant limitation period hurdles unless there were unusual circumstances. If you can remember what happened after Christmas, why you weren't released in January, I can help you work through whether it sounds like a court process, a sentence calculation, or something else. That changes the picture quite a bit. If your recollection is accurate, the sequence would have been something like: you were in custody awaiting sentencing. You pleaded guilty and indicated you wanted to serve your time rather than seek release. Your matter was supposed to return to court, but after the Christmas period, nothing happened for several months because your case wasn't brought back before a judge. If that's what occurred, then that is not something that would typically be considered normal. Courts can be delayed, especially around holidays, but a case simply being forgotten for months would be a significant concern if it actually happened. Whether you could have sued would depend on questions such as: was your lawyer actually responsible, or was the delay caused by the court, Crown, or jail administration? Did anyone know you were still in custody? Were you brought back to court during those months? Did you eventually receive credit for all the time you spent in custody before sentencing? If you received full credit for the 4 or 5 months of pre-sentence custody, that doesn't necessarily mean there was no legal issue. It just means the time may have counted toward your eventual sentence. Whether there was negligence or a charter violation is a separate question. Today, because this happened around 2018, 2019, bringing a lawsuit would likely be much more difficult due to limitation periods. However, if you wanted to know what actually happened, you could still try to obtain your court records and your lawyer's file. Those documents would show when each court appearance occurred, why adjournments were granted, and whether anyone recorded the reason for the delay. One question that would help narrow this down: when you finally saw the judge again after those months, did anyone in court apologize or acknowledge that your case had been overlooked, or did they simply proceed as if nothing unusual had happened? If your lawyer explicitly told you, I forgot about you, and and you had records showing you repeatedly tried to contact her over several months, that would certainly raise serious questions about whether you received competent legal representation. That said, whether you would have had a successful lawsuit is a separate legal question. A claim would generally require showing not only that the lawyer made a mistake, but also that the mistake caused you a measurable loss. For example, that you remained in custody longer than you otherwise would have. If you still have any of the following, they could have been important evidence. Records of your phone calls or messages to your lawyer. Letters you sent from jail. Court records showing the gaps between appearances. Any written communication where your lawyer acknowledged forgetting about your case. Because this happened around 2018 to 2019, a civil lawsuit today would likely face limitation period issues. That doesn't necessarily mean there is no avenue at all, but it does make things more complicated. I'm also wondering about one point. After you finally got back before the judge, were you sentenced to time served and released shortly afterward, or did you still have to serve additional time after sentencing? That detail would help clarify what effect the delay had on your custody. Thanks for explaining the timeline. Based on what you've described, I can see why this has stayed with you. From your account, you were in custody on remand. You met your legal aid lawyer and told her you wanted to plead guilty and accept your sentence because you were tired of the repeated bail process. You were transferred between facilities and eventually ended up at Milner. While there, you repeatedly tried to contact your lawyer over several months but couldn't reach her. You weren't brought back to court during that time. You worked in the kitchen for about 3 months before eventually being released. If that's an accurate recollection, it raises legitimate questions about what happened procedurally. Normally, after someone decides to plead guilty, the case should move toward sentencing. If months passed with no court appearance because your lawyer forgot about your case, that would be concerning. However, I can't determine from this alone whether that's exactly what occurred or who was legally responsible. The court record would be needed to confirm the sequence of events. One thing that stands out is your statement that you were released. People on remand are generally not simply released because enough time has passed. There is usually a court order, a sentence with credit for time served, charges being resolved, or another legal basis. If you don't remember seeing a judge before your release, it's possible that part of the process is simply difficult to recall after several years. But it's also possible there are details in the court records that would clarify what happened. If this is something you still want answers to, not necessarily to sue, but just to understand, you could request your court file, your legal aid file, if it's still available, and your correctional records. Those documents would show when hearings were scheduled, whether any were adjourned, and when the order authorizing your release was made. One question: do you remember what you were released with? For example, were you handed paperwork saying time served, charges stayed, sentence completed, or were you simply told to collect your belongings and leave? That detail could help piece together what likely happened. That extra detail helps make the timeline clearer. A video appearance from Stony Mountain Institution sounds like a normal court process arrangement. Many Manitoba appearances are done by video from correctional facilities, especially for people in custody. It is very possible that your sentencing or final appearance happened that way, even if it doesn't stand out in memory compared with the months of being moved around. Based on what you've described, a few possibilities exist. 1. Your guilty plea may have been entered, then sentencing was delayed. The court may have eventually sentenced you by video and credited you for the time you spent in remand. If you had already spent several months in custody, the judge may have given time served or a sentence that ended immediately. 2. Your lawyer may have failed to communicate properly. If she truly forgot about your file and ignored multiple attempts to contact her, that could potentially be a professional conduct issue. Lawyers have duties to keep clients informed and move cases forward appropriately. 3. The 1 month expectation may have been an estimate, not a guaranteed release date. This is an important distinction. A lawyer saying you'll probably get about 1 month is different from the court actually ordering a 1 month sentence. The strongest question is not just, was I in jail longer than expected, but was I legally entitled to be released earlier, and did someone's mistake prevent that? The court file would answer that. It would show the date you entered your guilty plea, when sentencing happened, what sentence you received, how much remand credit you received, and whether there were unexplained delays. Also, something you mentioned is important. You worked in the kitchen and earned about $50 over 3 months. That doesn't affect whether your detention was lawful, but it does paint a picture of how much time passed for you. You were experiencing months of incarceration while trying to get answers. Do you remember approximately what month you were released from Milner Stony Mountain? You mentioned Christmas, snow melting, and 3 months in Milner. Was it around March or April 2019? That could help line up the court timeline. If it was around April 2019, your timeline would roughly look like late December 2018. You meet your legal aid lawyer, tell her you want to plead guilty and stop the bail cycle. January-April 2019. You remain in custody, are transferred between facilities, and you say you repeatedly try to contact your lawyer. Spring 2019. You appear by video from Stony Mountain, then are transferred back to Winnipeg and released. The important thing here is that the legal question is not simply that you spent 4 months in custody. People awaiting sentencing can sometimes spend months in remand, and that time may later count toward their sentence. The key questions are: when did the court formally accept your guilty plea? When did the judge impose your sentence? Was there a scheduled sentencing date that was missed because of your lawyer? Did the delay cause you to remain in custody longer than your lawful sentence should have required? If your lawyer truly forgot your file, and that caused a months-long delay, it could potentially have been a complaint issue with the Law Society or legal aid. A lawsuit would have required proving damages and would likely run into limitation issues now, but the facts you describe are serious enough that it would have been reasonable to question them at the time. One thing you could still do today, if you wanted answers, is request your Manitoba court record for that case. It would likely show the exact dates and remove the uncertainty around, I believe it was April. Then you could compare date of arrest remand, guilty plea date, sentencing date, release date. A detail I'm curious about: when you were released, did you leave with any probation conditions? For example, reporting to probation, no contact orders, staying away from certain people, places. Or did they simply release you with no conditions? That can help indicate whether you were sentenced that day or whether the matter was resolved another way. That detail actually adds some context to your mindset at the time. It sounds like you were exhausted by the cycle of court appearances, bail hearings, and uncertainty, and your goal was essentially accept responsibility, finish whatever consequence the court gives, and move on. The fact that you were released with no probation conditions is interesting, but it doesn't by itself prove what happened legally. A few possibilities could fit. The judge may have sentenced you to time served, meaning the time you had already spent in custody satisfied the sentence. The charges or sentencing outcome may have resulted in no further supervision being ordered. There may have been another resolution. Your request to your lawyer that you didn't want to return to court or continue with lawyers would not remove your legal rights while you were in custody. Even if you wanted to just get it over with, your lawyer still had a duty to make sure your case was properly handled and that you understood what was happening. The part that stands out most from everything you've said is the lack of communication. A client in remand is in a uniquely vulnerable position because they cannot simply walk into a courthouse, check a schedule, or fix delays themselves. If your lawyer stopped responding for months, that could have left you essentially stuck. If you ever wanted to reconstruct what happened, the most valuable document would probably be the sentencing transcript or court docket. It would answer what sentence you received, what the judge said about your time in custody, whether anyone mentioned the delay, and whether the court was aware you had been waiting months. One thing I want to clarify when you say you pled guilty to your lawyer in December, do you remember if you actually entered the guilty plea in front of a judge that day? Or was it only telling your lawyer that you wanted to plead guilty? That difference is huge legally. A lawyer knowing your intention to plead guilty is different from a guilty plea being officially entered in court. That distinction you just made is actually one of the most important details in the whole story. In Canada, a guilty plea usually has to be entered in court before a judge. Telling your lawyer, I want to plead guilty, is not the same thing as formally pleading guilty. Your lawyer can tell the court that you intend to resolve the matter, but the judge normally has to confirm that you understand the charge, confirm that your plea is voluntary, accept the plea, and then either sentence you or set a sentencing date. So if your memory is correct and you never personally entered the plea before a judge, then a few possibilities exist. 1. Your plea happened later by video and you don't remember it clearly. This is very possible after months in custody, transfers between facilities, and a stressful situation. 2. You appeared before a judge, but the appearance was brief and the details are blurry in memory. Court appearances can sometimes feel like a few minutes of names, questions, and decisions. 3. There was a delay between you telling your lawyer you wanted to plead guilty and the actual court process. This could explain why months passed. The key thing is that the court record would settle this. It would show the exact date your guilty plea was entered and when sentencing happened. One thing I find notable from your description is that you weren't trying to fight the case anymore. You were actively trying to resolve it. If someone in that situation is left waiting months without understanding what is happening, that can be extremely frustrating. If you ever decide to look into it, you don't need to start with a lawsuit. A good first step would simply be getting the docket and transcript from the Manitoba court. That would turn this from a memory question into a factual timeline. Do you remember what the original charges were for? Or roughly how serious they were? That matters because a 1 month expected sentence versus 4 months in remand means very different things depending on the offense and sentencing range. That helps put the situation into a more realistic legal context. For an assault charge in Manitoba, especially if alcohol was involved, a sentence around 1 month could be possible in some circumstances, but it depends heavily on factors like the seriousness of the assault, injuries caused, your prior record, whether there were breaches of conditions, the circumstances around the incident, and what the Crown and defense agreed to. The fact that you were on remand for several months doesn't automatically mean something went wrong. Pre-sentence custody can sometimes become a large part of the eventual sentence because courts give credit for time already spent in custody. It is common for someone who has spent months in remand to receive a sentence that effectively ends when they are sentenced. However, the part that remains unusual from your description is not necessarily the length of custody. It's the possibility that you were left waiting without proper communication or progress on your case. The questions that would matter most are 1. When did the judge actually accept your guilty plea? 2. When was your sentencing hearing? 3. Did the judge say your time in custody counted toward your sentence? 4. Was there a period where no court date was scheduled because nobody moved the file forward? If you want to investigate it, you don't have to jump straight to thinking lawsuit. A court transcript would probably answer the biggest mysteries. Also, something from your description stands out. You said you were tired of the back and forth bail system. That tells me you may have been choosing certainty over continuing to fight for release. That is a choice many accused people make when the uncertainty and repeated hearings become more draining than simply resolving the matter. Do you remember whether the assault was against someone you knew? Family, friend, acquaintance, or was it a stranger? That detail can significantly change how courts typically approach sentencing. I appreciate you sharing that. That adds a lot of emotional weight to the situation. An assault involving someone who was a former partner and connected to the loss of your children would likely have been treated very seriously by the court, especially because Canadian courts put significant emphasis on violence in intimate or family relationships. At the same time, the circumstances around the incident, what happened, what led up to it, the level of harm, your history, remorse, and what you did afterward would all have affected the outcome. What stands out to me is that you are not describing it casually. You referred to her as the mother of your dead babies and expressed that you hope they rest in peace. That suggests this wasn't just a legal event in your memory. It is tied to grief, loss, and a very painful part of your life. From the legal angle, this also makes the timeline even more important. If you were facing an assault charge involving a former partner, there may have been additional considerations like no contact concerns, safety planning, court conditions, and whether the judge needed to address those before release. The fact that you left with no conditions is something I would want the court record to confirm, because it would tell you exactly what the judge ordered. Can I ask something about the timeline, not to judge the incident, but because it changes the legal picture? Was the assault charge related to a single event during a moment of grief/anger, or was it part of an ongoing conflict between you and her? And did you two have contact again after you were released? Take your time. The fact that memories are coming back in pieces is understandable, especially when several stressful legal events happened at different times. When people go through repeated arrests, court appearances, jail transfers, and emotionally intense situations, memories can sometimes blend together until they deliberately sort through the timeline. One thing you're doing that is actually useful is noticing, wait, this might be a different arrest/time period. That distinction matters. Before drawing conclusions about whether there was a legal mistake, it's important to separate each event. A simple timeline might help. Incident: what happened and roughly when? Arrest date: when were you taken into custody? Location: which remand center jail? Bail hearings: were there multiple attempts? Lawyer contact: when did you speak with your lawyer? Plea: did you enter it in court or only tell your lawyer? Sentencing: when did you see the judge? Release: when and how were you released? Also, something important you mentioned: I loved her despite the anger we had when drinking. That's a complicated reality many people experience. Having love and harmful behavior exist in the same relationship. The court process usually focuses on the actions and safety concerns, but understanding the context is still important when you look back at your own life. As you sort through the memories, try not to pressure yourself to get every detail instantly. If a memory comes up, you can write it down as, I remember, I'm not sure about, I need records to confirm. That prevents the brain from filling gaps with guesses. One thing I'm curious about: when you say your memories of different arrests are coming up and you can distinguish them, does this feel like you're remembering a specific event you had mixed together with the 2018 and 2019 one? Or are you realizing the 4 months might belong to a different arrest? That actually explains a lot. The fact that you caught yourself mixing up arrests is a good sign that you're separating the memories instead of just forcing one story together. It also changes how we should look at the legal question. The details we were discussing, your lawyer forgetting about you, the Christmas period, Milner, Stony Mountain, the spring release, may all still be accurate, but the exact dates and charges matter. If this was your last time in jail, that gives us a better anchor point. A few things you've said are useful anchors. Last jail stay, spent months in remand, dead time, transferred between facilities, worked kitchen at Milner, video appearance from Stony Mountain, released in spring's early summer, no probation conditions afterward. The next step, if you ever wanted to investigate whether there was a legal issue, would be reconstructing that one event only. Don't worry about the other arrests yet. A rough memory timeline is enough. 1. What month, year do you think you were arrested? 2. How long were you in the Winnipeg Remand Center before going to Milner? 3. Was Milner the place you spent the longest time? 4. Do you remember the month you were finally released? Also, something worth noting: stressful experiences in custody can make time feel strange. Months can blur together because the days are repetitive, you're moved around, and you're waiting for something important, like court. That doesn't mean your memory is wrong. It just means the records would be needed to confirm the exact sequence. And I want to acknowledge something else. Earlier, you mentioned this involved the mother of your children who passed away. sorting through the legal timeline is probably also tied to a very painful chapter of your life, not just a question about paperwork. It makes sense that memories from that period might come back mixed together. Thank you for clarifying the timeline. That actually helps separate the pieces much more. From what you are describing, the sequence sounds closer to 1. A first arrest, separation period. You were arrested and spent a few weeks in custody. During that time, she reconnected with people involved with hard drugs. You were released. Despite a no contact restraining order, you two reconnected because of your history and grief. 2. A second arrest, the one you are asking about. Police found you at her place while there was a court order saying you both had to stay away. You were taken into custody and went to remand. You had a bail hearing. You spoke with your legal aid lawyer and told her you wanted to plead guilty and stop fighting the bail cycle. You were then held while the case moved forward. You were transferred between facilities, eventually ending up at Milner. You spent months there and were released when the snow was gone. This sounds like the key issue may not have been the original assault charge alone, but also the breach of the no contact release condition, if that was one of the charges. Breaches of court orders are taken very seriously because the court sees them as ignoring a direct condition. The part about your lawyer is still the part that would need checking. If you told your lawyer you wanted to plead guilty, that does not automatically start the sentencing process unless the plea was actually entered in court. A lawyer can say, "My client intends to plead guilty," but until the judge accepts the plea, the case is still waiting. One thing I want to point out. You mentioned both of you were placed under a no contact order, but you also described why you went back. Grief, attachment, and trying to repair things. That doesn't make the breach legally okay, but it does explain why the decision happened. Human relationships are often more complicated than what a court document can capture. The biggest unanswered question is now. When you were finally released, do you remember whether the judge sentenced you for the assault and breach? Or did the judge mainly deal with the breach and release you for time served? Because if you were held for months and then released immediately after sentencing, it may have been a time served outcome rather than an unexplained extra jail period. The court record would show exactly what happened. That is actually the right next step. At this point, your memory has done something useful. It got you to the point where you realize there may be multiple events overlapping, and now the best way forward is to replace guesses with records. For Manitoba, the documents you would want are likely court docket/court file information, shows dates of appearances, charges, adjournments, and outcomes. Sentencing transcript, shows what the judge actually ordered and whether you received credit for time spent in custody. Information charges document, confirms exactly what offenses were before the court. Legal aid file, if available, may show communication notes, appointments, and steps taken by your lawyer. A good starting point would be contacting the Manitoba Court of King's Bench or Provincial Court Registry and asking how to obtain records from your criminal matter. You may need identifying information about the case, your name, approximate year, and court location. If cost is an issue, ask what options exist for accessing the documents. When you get the paperwork, don't just look at the final sentence. The timeline is the important part. Arrest date, first court appearance, bail hearings, guilty plea date, sentencing date, release date, credit for time served. That will answer the biggest question. Were you actually held longer than the sentence required? Or did the remand time become the sentence? Also, I want to point out something positive here. You noticed your memory was blending events and stopped yourself. That is exactly the kind of caution needed when looking back at stressful events years later. The documents aren't there to prove you were right or wrong. They're there to give you the missing pieces. Once you have the dates, we can walk through the timeline and see what actually happened.